Well, good afternoon and welcome to our live audience. This is the latest edition of the Texas Public Policy Foundation weekly policy live stream broadcast. To those of you who've joined online, thanks for doing that. Right now, you outnumber our live audience, but rest assured that will not be for long. Nonetheless, we're grateful that you tune in each week. We're grateful to our live audience. We're looking forward to having a lot more live events because that's what a free, self-governing people happen to do. And that's spend time together in person, in spite of what the news says. So it is a great pleasure to talk about the news of the day, which is Judge Amy Coney Barrett's nomination to the U.S. Supreme Court. I'm Kevin Roberts, Executive Director of TPPF, and I'm joined by three of my colleagues today. I'm going to be on my best behavior because they're three attorneys, and I know that I'll get in trouble if I say things that really are out of line. My good friend and colleague, Rob Henneke, our General Counsel, Director of the Center for the American Future. That's our litigation center. It's also known as the Great Hope for the Future of America, especially if upcoming elections go the way that the left would like. We'll be there fighting. Rob will be leading the charge. His colleague, our good friend, Chance Weldon, an attorney in that same center, and joining us from the great state of Tennessee, our State Initiatives Director, Tennessee State Director for Right on Crime, Julie Warren. To Julie, to Chance, to Rob, thanks so much for making time for this today. So obviously, Chance, we're here today to talk about something that starts a week from this moment, and that is the Senate's consideration of President Trump's nomination of Judge Barrett to the Supreme Court. She has been described, this is coming from a layman, she's been described as a textualist, as an originalist. What does that mean for those of us who are not attorneys, and what significance is that going to have, first in her hearings, but then secondly, presuming that she is confirmed, to her tenure as a Supreme Court justice?
Well, I think that just from a layman's perspective, textualism is this radical idea that the first thing you should look at when you're trying to interpret the meaning of the law is the text. And that the meaning of that text is set at the moment that the law is passed. And that as a judge, you should try to evaluate what the original public meaning of the words on the page were. Whenever you're trying to decide what a statute means, what a constitutional provision means, or what anything else means. Now, the court, as it sits right now, is effectively, they all claim to sit somewhere along that spectrum. Even Justice Elena Kagan claims at times to be a textualist. But as we know, historically, it's something that was popularized by Justice Scalia, which is Judge Barrett's mentor. And right now, that would put her with Justice Gorsuch and Justice Thomas as three committed textualists on the court. And that'd be the first time that we've ever had three committed textualists on the court that feel bound by the actual text of the Constitution.
Well, for those of us who agree with that philosophy, I think that's optimistic. I appreciate that. So, Rob, just sort of moving chronologically here into this process, the next question beyond Judge Barrett's judicial philosophy would be her qualifications, her experience. And there have been some critics of hers on the left, just to offer a devil's advocate question right up front, who have suggested she does not have enough of a track record to be considered for a seat on the Supreme Court. Respond to that specifically, but also explain to us more generally why you happen to believe she's very well qualified for this position.
Well, thank you, Kevin, and glad to have the discussion today. First of all, TPPF has seen firsthand how very analytical, how very smart Judge Barrett is. One of the very first major opinions that Judge Barrett signed on to was our case, a case that we won up in the Seventh Circuit, Orchard Hill Building Company versus the Army Corps of Engineers. And that was we represented a private land developer where the Army Corps of Engineers had claimed that our client's land was a wetlands and therefore subject to federal jurisdiction, even though our client's land was 13 miles away from the nearest navigable waterway. And I remember when we argued the case up in Chicago, how thorough and how precise and how fair Judge Barrett was in the examination of my colleague who argued the case, but also in the examination of the government's lawyer. She put both of us through the paces. And the opinion came and found that the Army Corps of Engineers had not done its job in putting together sufficient information in order to claim authority over our client's land. So we won. But I was impressed by just how well she knew the material and how detailed and analytical she was. And I think that fits into her background, Kevin. On paper, Judge Barrett is incredibly qualified. And it's ludicrous. It's absurd for those to say otherwise. Starting out where she graduated a very top of her class at Notre Dame Law School. She had won an award for having the best exams in 10 of her classes. She was summa cum laude. She was the editor of their law review, which is the very prestigious journal that she has at Notre Dame Law School, which is a very highly ranked law school. From there, she went and did 2 very prestigious judicial clerkships where you go work for a federal judge. She worked for the DC Circuit, which second to the U.S. Supreme Court is considered to be the second most important federal appellate court in the country. And then she had a clerkship for Judge Scalia, where she became very close for him. Kevin, after that, she went to work for a major Washington, D.C. law firm, a very prestigious law firm. So she has actual experience for a couple of years. And then she's been a professor of law for the past 18 years, 17 years, approximately until her confirmation in 2017. She's been an appellate judge for 3 years. That is an amazing resume. It checks all the boxes. If you look at the other justices who have been confirmed, she's equal, if not superior, in ways that I would compare it. And I think that she's going to perform admirably on the Supreme Court, as she's already proven to be able to do so on the U.S. Court of Appeals for the Seventh Circuit.
Well, thanks, Rob. I'm sure our audience appreciated the comprehensive nature of that response, because that's often lacking in what we're seeing on news, on TV news and hearing on the radio. And so, Julie, I want to turn to you because you've got some experience having clerked on the Senate Judiciary Committee. And it's a question about process. So we know about Judge Barrett's philosophy. We're going to get into in the next questions after process about what we can expect in the future. But I know many members of our audience are curious about what the process looks like. We know that formally it begins a week from now, but obviously there are some important meetings happening now. Walk us through that. Walk us through what you're expecting at the committee level, and then ultimately what you think the outcome will be.
Yeah, so, Article 2 of the Constitution gives the president the authority to appoint, but the Senate has the advice and consent authority to appoint to the Supreme Court. And so usually that process is about a 2.5 month process between the time the president nominates to the time the individual gets a hearing. And usually during that time, that nominee is meeting with all the members of the Senate, regardless of whether they're on the Judiciary Committee or not. They usually will meet with every member that is willing to meet with them. And also during that process, every opinion, every academic writing, every speech is submitted for review to the member staff so they can fully vet that individual. There's an FBI background, a very comprehensive FBI background check that also takes place during this time. So this is going to be a little bit different in the sense that Amy Coney Barrett was nominated on September 26th, I think, and she's going to have her hearing October 12th. So that's a rather abbreviated schedule. However, there is, it's not unprecedented, and I think that the 3-week period or 2-week period that she's going to get isn't enough. I think that there's been a lot of preparation on the front end to have all of those documents ready to hand over immediately to the Senate. So I'm sure, because she has been on the short list for a very long time, there's been a lot of that front work already done, I think. So the majority leader clearly has a comfort level to proceed with her hearing on October 12th. As far as what that will look like, I think that if I were preparing this nominee for her hearing, I would say be prepared for everything. I think if the Kavanaugh hearing taught us anything, it's to be prepared for everything and don't have a preconceived notion as to what to expect. It will be interesting to see how Lindsey Graham proceeds over these hearings. I think he'll probably lead with a very strong gavel. And so that will be good. So I think it will be a very controlled hearing. I think that he'll maintain order. And then I probably will go along party lines. And if the majority leader has his way, I'm sure he probably wants to proceed with a vote prior to the election. That may or may not be possible. This is kind of unprecedented in the sense that the timing of this hearing. So I'm not sure exactly what to expect, but I think we can also expect the nuclear option to be utilized to push a cloture vote. And I'm sure he'll do it as soon as he possibly can, but it's possible that it could be a lame duck vote. It's really hard to tell at this point.
And Kevin, just real quick, I would jump in there to say the work is 90% done.
Yeah.
When Judge Barrett was confirmed to the Seventh Circuit Appellate Court, she had to go through all the background checks. She had to go through the FBI. She had everything that she had written since kindergarten scrutinized by the Senate Judiciary Committee and by the members of the Senate. I'm hardly examining. The packet of information, everything she had written in 15 years of academia at Notre Dame, everything she'd written in law school, every case that she'd been involved with, all of that was gone through and examined by Senate Judiciary. She was examined by the FBI. And so since 2017, what's she been doing? We know she's been on the Seventh Circuit, and all of her work has been public in the form of opinions or dissents that she has joined and written onto. So I don't feel like it's rushed because the work has already been done. Everything that was done prior to 17 is already archived, and it's really very transparent and open, anything since there. So she's ready to proceed forward, and there's no reason that this is abnormal on the time frame.
Okay, well, thanks. I think that's helpful for our audience who's trying to grapple with what we all understand as a pretty compressed timeline. So Chance, let's just assume for the sake of the rest of today's conversation that Judge Barrett's confirmed to the Supreme Court. If so, unless I'm mistaken, she would be the only one of the 9 justices who has not had experience representing the executive branch. And ironically, perhaps fittingly, the only other one is the now deceased Justice Ginsburg. Why is that important, and how do you think that's going to affect or influence Justice Barrett's decisions on the court, as well as affect and influence her colleagues on the court?
Yeah, I think that really matters. Right now, all of the other justices on the Supreme Court used to work for the Department of Justice, used to defend for a living government actions, executive agency actions. And as a result, over the years, what we've seen is most of those justices have a highly deferential attitude when it comes to judging the actions of the executive branch. We haven't seen that from Judge Barrett. We haven't seen that, for example, the case that we were in front of Judge Barrett for that Rob mentioned earlier. The question in that case was whether or not the court had to defer to evidentiary findings by the Army Corps of Engineers. And what Judge Barrett said in that case, well, what she joined the opinion that said is, if the Army Corps of Engineers wanted to regulate private property, that it had to check all the boxes. It had to go out and look and make sure that it had a justification for doing so. A lot of other judges wouldn't have made that call, but Judge Barrett and the other judges on that panel did. And so having someone with that skepticism towards government power, particularly that skepticism towards unelected bureaucrat administrative agency power, I think is important to have on the court. And I'll add one sort of caveat and interesting story for that is, one of the most controversial decisions about deferring to administrative agencies is a case by the name of Auer. And that case, people forget, was written by Justice Scalia. And it was shortly after he had worked as a government attorney representing administrative agencies. And he held that the court should defer to administrative agencies when interpreting the law, when exercising their fundamental judicial role. And for the rest of his career on the Supreme Court, he regretted that opinion and tried to take it back. And so to have someone on the court that doesn't have that background, I think is extremely important in matters of criminal justice and in matters of administrative law.
Thanks, Chance. So Julie, next question's for you, and it's dovetailing with Chance's response just now, as well as something Rob said earlier about Judge Barrett's paper trail. And
Mhm.
so I'm curious if there's something that sticks out to you or some set of topics that stick out to you from her academic papers or from her decisions that might be really telling for those of us who are watching and sort of expecting her to be a stalwart conservative justice on the court.
Well, she's written extensively about stare decisis that I believe will probably dominate the hearings. She's clearly willing to accept certain levels of stare decisis. She's written extensively in terms of her interpretation of how Scalia viewed stare decisis.
And just explain for people who may not know what stare decisis is.
Well, stare decisis is basically precedent. It's basically the court's willingness to adhere to its previous precedent. It's a simplistic view of it. And there's been, a lot of originalists will say we don't worry about precedent as much as we worry about the original text of the Constitution. And then you have someone like Scalia, who always was able to sort of draw this fine line between saying, yes, I'm an originalist, but you know what? I have a pragmatic view of what stare decisis means, and there is a place for stare decisis. And it would appear that Amy Coney Barrett adheres to that way of thinking. However, she does clearly state that she believes that there should be a weakened stare decisis. So to the extent that there is clear error, she believes that stare decisis is less important than originalism. And so I believe that's probably going to be a real sticking point for the Democrats on the Senate Judiciary Committee. I believe a lot of her extensive writing on that issue will take up a lot of oxygen during her hearing, because she's written extensively about it. And oftentimes when nominees come in front of the Judiciary Committee, stare decisis is a very high profile topic, but there's not necessarily a lot of their academic input, and they have not actually put themselves on the record as much as she has. So it will be interesting to see how that goes, but I think she's already drawn a very clear line in the sand where she stands on that. So there's not a lot of ambiguity there.
Thank you. So Rob, again, assuming that Judge Barrett is confirmed, we know that the court will shift ideologically from, roughly speaking, with an occasional exception, 5 conservative justices and 4 liberal justices. Presumably, if Judge Barrett's confirmed, that becomes a 6-3, quote unquote, conservative majority. What does that look like in terms of upcoming decisions that are imminent for the court, but also looking down the road 5, 10, maybe 20 years, big topics that you and your attorney colleagues are tracking here at TPPF? How important is that shift if in fact it happens?
It's critically important. I mean, as much as we'll see in the next couple of weeks that the left is going to, try to attack Judge Barrett and to suggest that, she would not be neutral, she would not be impartial, she'd not be bound by the text, where you've had the most consistent voting block on your high profile type cases have been among the left, where the left of former Justice Ginsburg and then Justices Kagan and Sotomayor and Breyer have hung together and have tried to pull over a vote from what's considered to be this conservative bloc. It hasn't gone the other way around. You've not seen on any of these cases Ginsburg, Kagan, Sotomayor, or Breyer break and join the other way. It's really, I think the potential here is about depoliticizing the Supreme Court. We should not, the framers did not design Article 3 of the judiciary to have the level of importance that we're going to see and the level of angst and partisanship there. That I think that with Judge Barrett's addition to the court, you're going to see a stronger majority that's going to be willing to adhere to the text of the Constitution, being willing to limit and restrain the power of the administrative branch and of the federal government. But I also think that you're going to see less inclination of the left, particularly seeking to take these home run cases to go and seek to have the Supreme Court create rights that don't exist under the Constitution, to create law that doesn't exist under the Constitution, to create policy that they've not been able to obtain through the legislature or either with Congress or the states. And so if that then becomes a case, I think you restore balance in many ways to what was intended among the three branches of government, and also what was intended between the states and the federal government, that, you know, if the left can't trust to have a good chance of winning a home run case at the Supreme Court or potentially losing a case there, then they should shift focus to where it was intended, which is the Congress, or for most everything, the states. And I really hope that in 10, 20 years, Judge Barrett continues to serve with distinction, but that the Supreme Court has largely become much lesser importance because we're no longer looking to the Supreme Court to be a super legislative body. And instead, we've gone back to the process as it has intended, with judges who are executing their roles faithfully and honestly.
So, Chance, I want to ask you a follow-up question to that, and it's about the Chief Justice. And of course, we respect him and respect his office. Yet, for those of us who are conservatives, there's been a certain level of consternation about a perceived lack of consistency. And so I'm curious, again, as a layman, and probably speaking on behalf of most of our audience members, what you might expect as a very close court observer might happen with the Chief Justice, both in his own judicial decisions, but also in his leadership of the court, if Judge Barrett is confirmed.
Well, I think one of the most important things that the Chief Justice does is he assigns opinions, right? If he is in the majority, he gets to assign who writes the opinion. So in a lot of cases, you've seen historically, he may be a swing vote so that he can, join with the previous four liberals and then maybe push an opinion one way or the other. We saw that in the first ACA case back in 2012. And so you're going to see him in the majority getting to decide who writes these opinions. And if these opinions are going to Gorsuch or Barrett or Thomas, he can move the court very much to the right. Or if he decides to write the opinions himself, he can moderate the trajectory of the court. Another real important thing that you're going to see, and I think the number being 6-3 as opposed to 5-4 matters the most for this, is what cases the court takes. The court doesn't have to take any case that goes up on appeal. They have discretion. And I fully expect to see Justice Roberts wrangling behind the scenes to make sure that certain cases go forward and certain cases don't. And we've seen that already last term with the cases dealing with the Second Amendment rights. And all of a sudden, none of those were granted cert and heard, largely because I think they didn't have the votes necessarily. A 6-3 court is much more likely to hear those cases.
Thanks. So, Julie, we're going to switch gears here just a little bit, moving away from Judge Barrett's philosophy to something she's been derided for very distastefully, and that's her faith. And I'm curious from your perspective as an attorney, also someone who's clerked on the Senate Judiciary Committee, what you think about those attacks generally, if in fact they're relevant and fair. But secondly, let's actually play the devil's advocate and at least momentarily take the position of Senator Feinstein and say that it's impossible for a Justice Barrett to be neutral. What do you think about that? How do you respond to those questions?
Well, first off, she's already on the record as saying that she doesn't believe her religious convictions play into her jurisprudence. And she said that she believes it should never do that. She also believes there should not be a litmus test as to a person's religious affiliations to be on the court. So she's already, and I'm willing to believe her because there's no record to assume she would do otherwise, right? So I do believe that she is a very objective jurist, and there's no evidence to suggest she isn't. As far as playing the devil's advocate, I think at the end of the day, everybody goes into this process as a human being with their own worldview, whether that worldview is informed by their religious convictions or their absence of religious convictions. And that worldview does that impact how they analyze an issue? I mean, her being a Catholic is probably just as puts her on the same footing in terms of worldview as someone who is saying I'm agnostic. I mean, they both have worldviews that they're walking into life with. And so I think that for Feinstein to suggest that she's disqualified and otherwise incapable because her worldview happens to coincide with the Catholic faith is ridiculous. I mean, it's ridiculous, and she has no evidence to prove that to prove that point. And so I think that it's obviously they're going to use her religious affiliations as political gamesmanship. I mean, that's what they do. I mean, they did that to Roberts, they did it to Gorsuch, they did it to Kavanaugh. And it's a thing that they do, and I think she's probably prepared for that. But she's been on the record as saying that she does not believe her religious ideology informs her practice as a judge, and I believe her because there's nothing to suggest otherwise. And for Dianne Feinstein to suggest that Catholicism is a disqualifier because it removes their ability to be objective is just unfounded to me.
Chance?
I just wanted to chime in there. One of the things that that's floating in the background of all of that as well is that the text of the Constitution itself says there shall be no religious test, right? There shall be no religious test. And there's good reason for that. And it's because of the very things that we're seeing here from the Senate. So I agree that there's no indication that, Amy Coney Barrett is anything other than objective. But I think it's both shameful and unconstitutional for these attacks to go forward.
Well, I'm glad you said that, because I was thinking as Julie was giving us her wonderful analysis of the recent confirmation hearings of Russ Vought, now the director of the Office of Management and Budget, who was derided for his Christian faith, not Catholic, but another denominational faith. And he actually invoked the text of the Constitution and said, this is beginning to sound like a religious test. And just to put some layman's underscoring on this, that's the objective of some members of the left, to make it impossible to be someone of Christian faith and serve in these high offices. And as I like to say, even atheists should have a problem with that, because if we succeed with that, we succeed with abrogating all of our other rights. So I'm real grateful for the conversation thread here. So Rob, I'm going to ask you a last question for you, and the last question for Chance and also for Julie, and then we're going to turn to the audience, both live and online. So if you have a question online, be sure to post that in the comments box of whatever social media channel you're on. For you, Rob, the obvious question, elephant in the room question, is about the Affordable Care Act case. So let's say we have a Justice Barrett. What changes about that case? And just remind our audience as well what the timeline is.
Well, certainly. So the week after the election, so approximately 5 weeks from today, the Supreme Court will have oral argument on the case that I'm lead counsel for, the individual plaintiffs, which is the constitutional challenge to the Affordable Care Act, where we, based upon the prior holdings of the Supreme Court, have shown that, after Congress got rid of the individual mandate penalty in 2017 in the tax cut bill, what was left, the individual mandate that the federal government says you are commanded to go buy the insurance the government tells you to have to buy, is unconstitutional. And we know that because Justice Roberts said that it was in his majority opinion in 2012. A couple of things to note is that, one, 4 justices at the time agreed that was wrong, and were very critical of that. Justices Thomas and Scalia and Kennedy and Alito wrote in their dissenting opinion they disagreed with Justice Roberts's analysis there, because Justice Barrett also at the time of the opinion was critical of that reasoning and of that analysis. So she doesn't stand alone there, and certainly she's joined by some amazing jurists on the court that were critical of that. But where she comes in the case is also one that is going to be bound by the court. And I think the question that she'll have there is in terms of the severability doctrine, where really the constitutionality of Obamacare has been shown to be defective. But with an omnibus statute that has so many provisions in it, everything from the mandate and the requirements in health insurance to the fact that restaurants now have to put a calorie count on their menus because the federal government says so. Everything in between was thrown into that bill when it was passed by the Democrats in 2010. Question for the court to grapple with is, when the individual mandate is struck down, does everything else be severed off with it? And you can see that she's going to join some divided agreements, even among the right on the court, where this question of severability has come up there. But at the end of the day, the text of the Affordable Care Act is going to control. The text of the Affordable Care Act says that this individual mandate is essential to the entirety of the act. And I trust that her vote will join those else on the right that have already opined on the court that means that the entire Affordable Care Act is something that has to be declared invalid and sent back to Congress to do over.
Thanks. Julie, I want to ask you a question of contrast, and that is the situation in 2016 with the nomination by then President Obama of Judge Merrick Garland to the Supreme Court versus the situation in 2020 where President Trump, with about even less time, just to be fair to the critics, has nominated Judge Barrett. What's different, if at all, between those two situations, and what defense might someone make of the situation this year?
Well, I mean, it's very nuanced, and I think your average American watching at home probably isn't going to appreciate the nuance, to be perfectly frank. In 2016, you had a Democratic president and a Republican Senate. The Republican Senate's job, well, the Senate's job is advice and consent, and you had a Democratic president sending them someone they probably didn't particularly want. Now it's a little bit different. You have a Republican president sending a Republican majority someone that they probably do want. So their advice and consent is a little bit, or their motivation is a little bit different. So I think that it's a fine line. I mean, I think a lot of people are probably going to be like, there's really no difference at all, practically speaking. But I mean, if you look at the Senate's role as to advise innocent and to be the one that actually appoints, I think you can make the argument that this is a Republican majority Senate, and you have a Republican president nominating somebody that they want to inform their opinions on, and they want to appoint. So I think that is the difference. Arguably, though, I mean, it's a very nuanced point, and I honestly believe it's going to be lost on most people, because I think that a lot of people are going to say, well, you shouldn't be politicizing, so it shouldn't matter what the party affiliations of whether the president or the majority of the Senate, but in reality, it does. So.
Yeah, and if we were writing the headline, we might say that in 2016, the Senate advised and didn't consent. And in 2020, they're advising and they're likely to consent.
Well, they said they don't want to advise and consent because, at the end of the day, I mean, there's a very good chance that Merrick Garland wouldn't have gotten through.
That's right. And then only somewhat, I'd say, I'll trade the left this example in 2020 for what they did to Robert Bork, and we'll call ourselves evil.
Oh, absolutely. Absolutely. I mean, yeah, I think you can, that's easy trade. Yeah.
Rob, you wanting to jump in, keep me out of trouble? Well, no, not to keep you out of trouble, but a great part of it is people are intentionally misrepresenting the constitutional framework in terms of the confirmation that, let's get rid of everything that he said, she said about what someone said in 16 and what someone says in 2020. Let's go straight to the Constitution. I mean, it is wrong to say that whoever the president picks, the Senate has to confirm. We know that's not the case. And sometimes the Senate acts by not acting. I mean, you have a partnership. There's so many parts of the Constitution where, given the separation of powers and the checks and balances, you have a partnership between two branches of government. Here you have a partnership under the Constitution between Article 2, which is the executive branch, the president who makes a nomination, and Article 1, which is the Senate that has to advise and consent to the nomination. Sometimes the Senate acts by not taking action. It did so in 2016 with Garland. It did so under the George W. administration when the president made an initial nominee who was never brought to a vote. And then it was Justice Alito who was subsequently nominated. So it is a partnership. The president and the Senate have to agree on a nomination in order to confirm that. That didn't happen in 2016. It may happen now. Historically, it has happened with the confirmation of the other justices, but that's how it works. And so if you don't have that agreement between the president and the Senate, then you're not going to have a confirmed justice. And the only way to work through that is for those two branches to work together. They were in opposition in 2016. They're not now. But the constitutional process is moving forward, and there is no hypocrisy on the way it's operating. It's operating now, and it operated in 2016 exactly as it was designed by the framers.
And governance is an inherently political process.
It is.
And people see the word political and think it's a terrible word. It's our nature as humans, and we're leaning on the Constitution very, very plainly when we look at the example of 2020. Where we're not leaning on the Constitution necessarily, Chance Weldon, is with this court packing scheme. And the left is using their depiction of the 2020 timeline as reason to be promoting court packing. So talk to us about the history of that and why it's such a truly deplorable idea.
Yes, it's a really dangerous idea. And to explain what court packing means is the way that the Constitution is structured, Congress gets to determine how many members are on the Supreme Court. Now, for the past 150 years, we've had 9 members on the Supreme Court. It's sort of been a tradition at this point. There was one attempt in the 1930s where President Roosevelt had floated the idea of adding justices to the United States Supreme Court and was rejected rightly by his Congress and by the American people. He suffered for that because in our system of checks and balances, the court plays a pivotal role. It's supposed to be a bulwark against the excesses of democratic governance. It's designed to be apolitical, to apply the text of the Constitution to protect the minority and protect individual rights from the mob. It's a very, very fragile fiction that the court is not a political institution. And what the American people realized in the 1930s is if you allow the president, whenever he's upset about what the court does, or Congress when they're upset about what the court does, to change the balance of that court, that fiction that we all rely on, it's on a knife's edge. And people start not paying attention to what the Supreme Court says. As Hamilton said years ago, they don't have the power of anything but judgment. They don't have troops. They don't have the power of the purse. And the only thing that holds it all together is that we respect their judgments and view them as neutral judgments. So this idea that the Democratic majority might sort of take its ball and go home and decide to pack the court, it's a slippery slope, because then you'll have, whenever power switches hands, people will pack the court the other direction. And pretty soon we'll be having oral argument in front of 25 or 30 members, and it'll look like the Imperial Senate in Star Wars when you're arguing. So I think it's a real dangerous proposition.
Thank you. Well, now has come the time for audience questions. We'll start with live questions here with our audience here in person. So please raise your hand if you have a question. Wait for the microphone so our friends online can hear the question. And then those of you online, if you have a question, just type your question into the comments box. First question. Yes, sir.
You had talked about Chief Roberts being the one to establish who would be writing the opinions. Who is it that chooses the chief of that court?
So the Chief Justice was nominated by the president, and that's a specific role. So when former Chief Justice Rehnquist passed away, then it was President George W. Bush that appointed John Roberts to be the chief. And so he will serve then as the chief of the Supreme Court. Sure, he's one vote of 9 among the justices, but he has that specific designation because he was appointed into that spot by the president.
Next question. Yes, sir.
What are your odds that Judge Barrett gets confirmed either before or after the election?
Julie, you want to start with that?
Wow, odds. Assuming nothing changes, I think that Majority Leader McConnell knows how to get a judge confirmed. So I think if there's anybody who can do it, I believe it's Leader McConnell. And I the only thing they need is 51 votes. And I think I'm going to say I think that there's a good chance, if I had to put my money on it, that it's before the election.
100%. I mean, this is the Leader McConnell. Senator Graham is leading Judiciary. Leader McConnell has been shown to know how to move the Senate through its process. And, you already have a majority of the Senate that voted to confirm Justice Barrett 3 years ago and are also on record being in favor of moving forward with the confirmation process. So this is what the business of the Senate is, and they're going to get their job done.
I love your optimism. So first audience question goes to you, Chance, and it is a similar question about odds. What are the odds of success for a Democrat-controlled Senate, and also presumably if Joe Biden wins, attempting to pack the court?
I think that unfortunately it's high. I mean, historically, Joe Biden has referenced in the past that he was opposed to such plans, but now he's become suspiciously silent. And we know that his base will be calling for that. So I would put the odds at better than 50-50, which as I mentioned before is troubling when you think about it. But if they control both the Senate and the presidency, I think there's going to be a strong push to pack the court and do things like eliminate the filibuster in the Senate as well.
But I think history shows that the risk is on their side as well. I mean, Chance mentioned the current votes in the Senate for most everything require that you have to have 60 votes of senators in order to proceed. And that's been called the filibuster rule. It was actually changed by former Majority Leader Harry Reid, specific to judges. But this rule is a procedure of the Senate, and it's been threatened that the Senate would get rid of the filibuster rule in order to pass everything on a straight majority, and then would pass a law that would change the number of Supreme Court justices. That's how they would pack the court. Let's remember in 2010 when the Democrats jammed through the Affordable Care Act without any approval by the Republicans. They politically paid for it over 10 years with the swing, with the rise of Republican majorities in the state, with the recapturing of the Senate and the House and the White House. And so history has many examples, and both parties know it, that when a party has abused their power, as would be the case with court packing and ending the filibuster, neither of which the Republicans have done over the last 4 years, that the ultimate judgment will come from the people of America. And what may be a short-term gain will certainly be a long-term loss for those that abuse the power they have and really just change the rules and in order to cheat to win.
So the obvious follow-up question, Rob, then is it correct to say that the only recourse to a court packing scheme is at the ballot box, so that the risks you're talking about are in the next election or the election after that?
I mean, ultimately, that's where the accountability lies. In a government of limited powers, those powers derive from the people. They're not powers that belong to the government. And so, we'll see what the makeup of the legislature is and who occupies the White House after this. But we're a country that's founded on rejection of tyranny. And I think we'll continue to have those views. And also important to note that there are opinions the Supreme Court has come out with that one side or the other disagrees with. And, you know, you've had a number of opinions over the past several years that the right of the spectrum has disagreed with, that states have disagreed with. We've respected the rule of law. And so the temptation by those advocates from the left who want to change the rules in order to win needs to be rejected by, I think, the history of our country that has said at times we'll disagree, but we'll still be Americans and we'll still respect the Constitution and the process and just work to make our country better.
Thank you. So Chance, our audience clearly is real interested about this court packing business. And so there's yet another follow-up question, which is a good question. And I'll just read it verbatim. What are the reasons that we haven't tried to set the size of the Supreme Court through a constitutional amendment? Should we?
You know, constitutional amendments are hard. I think that's why I think that's a lot of the reason why we, you know, not to digress too much, but that's a lot of the reasons why the court has gone off the rails in recent decades in a lot of ways, is because the constitutional amendment process is hard, and some people have asked the court to go the easy route and avoid that. But there is, I believe, Senator Ted Cruz recently had talked about a constitutional amendment to set the court at 9. I think it's a good idea. I think it would be a good idea to take this sort of gamesmanship off the table.
Thanks for that. Julie, next question for you. This also from the audience. You're waving around there, but now you look.
Sorry,
Oh, it's quite all right. It's quite all right. I don't always get the opportunity to haze an attorney, so I just took the opportunity. Do you believe Barrett will agree with Thomas that stare decisis has been overblown?
Probably to a certain degree. I don't know if, because well, I mean, without getting into like the really nuanced, which, you know, you can really geek out over this stuff. Thomas and Scalia had this little tension over stare decisis, to where, you know, Scalia took a lot of criticism because he actually was willing to embrace it at times as a pragmatic necessity. I think he said he was a faint-hearted originalist because he was willing to accept stare decisis, to where Thomas is a little bit more critical of it. I think Barrett's probably more in the Scalia category. I think that she's going to be reasonably skeptical of it because I think she's an originalist, but I don't think she's willing to be as critical as Thomas. I think she's going to be willing to accept stare decisis as a pragmatic necessity to maintain court order. So I think she's probably going to be a little bit more along the Scalia than the Thomas view, in my opinion. I think she would probably say that. She's pretty much written that. So I think that's where she stands. She's going to be in the Scalia school.
Chance, Rob, any additions to that?
Yeah, I'm going to jump in on that. I laugh kind of because from the senators that bring this up, you know, to them, stare decisis means, you know, do you solemnly pledge that the cases that I agree with, you will always agree with, but then that doesn't apply for the cases that I disagree with? I mean, you know, we have a history of the Supreme Court making major errors in terms of civil rights, in terms of fundamental liberties, cases that we all would agree today never should have been decided that way. And, you know, if you want to take the stare decisis question to Senator Kamala Harris, who's on Judiciary, and say, Senator Harris, that would mean that you agree that Heller, which is the Supreme Court case that affirmed that the Second Amendment is an individual right, that stare decisis and always should be there, she's never going to agree to that, because she doesn't like the case. And so, you know, these Latin terms, these legal terms will be out there trying to box Justice Barrett into a commitment of deciding an issue a particular way, which is absolutely what she should not do. She should do what she's sworn to do, which she's been doing for 3 years, which is to faithfully evaluate the facts of the case based on the law as it's written, which is influenced by precedent, and decide her cases accordingly. So when we see some of this back and forth about stare decisis, let's look at it with the lens of skepticism and recognizing that whomever is crying stare decisis the most only agrees with it when it's for cases that they agree with.
That's very helpful for those of us who understand the concept of relativism, but hadn't really applied it in such austere settings. One final question from the audience, and then we'll move to the last comments. Yes, sir.
But building on that point about stare decisis, I think we see some of the loudest takes out there being the "what will happen" takes when Justice Barrett is put on the court. Now, do you all see a court, including Justice Barrett, kind of throwing out root and branch, basically progressive doctrine going back all the way to the Warren Court? Or might it actually demur from some of those questions because of, I would say a more traditional conservative principle of judicial restraint, or might it fall somewhere along that spectrum?
Well, I think it's interesting, Judge Barrett's actually written on these issues about, she talks about what they call super precedents. And the courts, again, we talked about earlier, the Supreme Court doesn't have to take every case. They get to be very selective about the cases that they take. And I think you're going to see a lot from Justice Roberts to the extent they start moving away from some of these bad precedents or precedents that are non-originalist precedents. I think they're going to take an incremental approach to rolling back some of the worst excesses without tearing things out root and branch. And I think that largely comes down to folks like, Alito and Roberts, and even based on some of her writings, Barrett. They do think stability matters in the law, but you don't allow bad, awful precedents to just sit around on the books forever. To Rob's point earlier, there are some really bad cases that we're very glad that they were overturned that I don't think anyone would disagree with. Plessy versus Ferguson, which said separate but equal. Korematsu, where they interned American citizens because they were of Japanese descent. Everyone agrees that those precedents should have been overturned. So I think we're going to see an incremental approach to undoing some of the very bad precedents that we've had over the years.
I'd also mention too, you're seeing some of the same fear mongering with Judge Barrett as was thrown out there when Justice Kavanaugh was put through the confirmation several years ago, and all of the outrageous predictions and claims by the left that would occur if Justice Kavanaugh was confirmed have certainly not come to fruition. So much of this is sensationalized, but I agree with how Chance has described how the court will methodically move through each of the cases and address the issues that gets put before it.
Thanks for that question.
Well, yeah, just one more point. I think it's important to point out that the vast majority, or more than a majority of the cases that come before the Supreme Court are decided 9-0. So when you're talking about these controversial 5-4 decisions, that is a fraction of the cases that come before the court. So this idea that it's going to be a radical shift that just undoes everything overnight, I just don't think it's backed up by history.
Well, great discussion. Panelists, excellent job. Audience members, thanks for some great questions. I think those of you who are panelists know that we have a custom on this live stream to conclude with some optimism, which is really timely considering how challenging 2020 continues to be. So Julie, we'll start with you. Feel free to be optimistic about the specific topic at hand, or if you want to be optimistic about more general things. I know our audience members would love to hear that from you.
Well, I mean, I'll stick with the subject matter, Amy Coney Barrett. I think she's a great jurist. I think that we're going to be blessed with a great jurist. I think that she's qualified and she's more than capable of assuming this post. And I think that she'll lead the court in the right direction. So I'm extremely pleased with this nomination.
That's great to hear. Thank you. Chance?
I think that it's going to be exciting to see over the next several years having just the intellectual firepower that will be there on the right now with the methodical textualists of Gorsuch and Thomas and Justice Barrett. The types of conversations the court will be having, the types of arguments the court will be having will be extremely exciting to watch, and I think will move the court in a very good direction.
Thank you, Chance. Rob?
I'm excited and optimistic to see on the national stage, this profile of what seemingly is an amazing woman, an amazing person. Let's set aside her academic credentials for a second. Judge Barrett just seems like a really great person. She's a person of faith. She has 7 kids. two of whom she rescued by adopting and adopted them from Haiti. She's mentioned the fact that she has a special needs child, and I'm sure that that is incredibly challenging. That she has done all of this, that she's a federal appellate judge, that she's had an amazing legal career, and she's committed family person and mom and has all of the struggles and difficulties of that. And I just think I'm so excited to see someone of her, I think, character introduced to the American people again, and to have this opportunity to celebrate, you know, the upcoming legacy and what she brings, and just it's gonna be neat to see just a really good person move forward and be put in a position to do great things for our country.
Well, audience, please join me in thanking Rob Henneke, Chance Weldon, Julie Warren for a wonderful conversation and for all the great work you do for this country. Congratulations.
Thank you.
You see why I'm the luckiest guy on earth. I get to work with people like this who of course are hard charging, but also optimists. Those two things go hand in hand, because all we're trying to do, as Judge Barrett personifies, is save the American dream. And so with our audience here in person, our audience online, thanks for making that possible. May God bless you and continue to bless this great country. Have a great day.